grateful if members who are leaving could do so quietly, please. The final item of business today is the members' business debate on motion number 9525 in the name of Graham Pearson on justice for survivors of historic institutional child abuse. This debate will be concluded without any questions being put, and I would be grateful if those members who wish to contribute could press the request to speak buttons now. I call on Graham Pearson to open the debate. Mr Pearson, 7 minutes, please.
Presiding Officer, thank you very much for the opportunity to move this motion and initiate this debate. Can I begin by welcoming back the Minister, who was absent last week due to illness, and it's good to have her back in the chamber. There can be no more important duty for civil society than to deliver on its responsibilities to ensure children placed in the care of institutions, whether local authority, religious or charitable institutions, and that those children deserve and receive love, care, support, protection and security. That society failed in that duty is a matter of record. The past evidence of it provides really no doubt. In 2003, the European Court on Human Rights, in the case of E and others against the United Kingdom, commented that the remedies for survivors in Scotland were inadequate. I don't imagine a review today would comment with significant difference. Institutional abuse of children is the ultimate example of failure in a duty of care, and government, as an agency by which standards are set, rules and laws are created, outcomes are measured, has the final responsibility in this matter. My reason for initiating this debate today was to give a voice to those survivors who have suffered, sometimes years and decades, the most horrific abuse at the hands of people whose sworn duty it was to protect them. In one case, a survivor, an adult who had for decades sought a meaningful apology and specialist counsel and support, contacted me to raise his case. His story was not only moving, but in the end, it was devastating. On his behalf, I made contact with the organisation concerned to seek assistance for him. I was referred to a lawyer. In that moment, I experienced the coldness and alienation felt so strongly by so many survivors. I don't know the number of victims affected by abuse at the hands of those who worked within children's care establishments, some of whom committed suicide. I don't even know now, and neither does this government. I can tell you that in Northern Ireland, the number quoted is 434. I don't imagine Scotland will have fewer survivors, and probably it has more. In Northern Ireland, they have initiated a public inquiry designed to be inquisitorial in its approach and not adversarial. An inquiry that sets out not only to respond to the experience of victims, now survivors, but to ensure that such abuse does not occur again and that services are in place to deal with the challenges. Jack McConnell, to his benefit, provided a government apology on behalf of the Scottish people to victims in 2004 and made a substantial step to begin a process that should have addressed the many issues raised by survivors. They wanted to see appropriate prosecutions where possible. They wanted forthright apologies from the right people. They needed professional support and counselling, and in some cases appropriate damages. Lord McConnell's apology, though welcomed by many survivors across Scotland and supported by the general public, did not, however, deliver accountability in relation to individual institutions, nor did it provide an effective apology to survivors in respect of their individual cases. Perhaps an apology law, as suggested by Margaret Mitchell, might go some way to freeing up an opportunity for bodies to finally come forward and deal with the shortcomings in a more open fashion. At the same time, the Minister should comment on current practice in relation to time bars applied in our civil courts in respect of ongoing cases involving historic abuse. To date, survivors do not feel their needs have been addressed in a positive and practical fashion. £6.2 million is estimated as having been spent creating the National Confidential Forum, funding various inquiries and reviews and debates that have come and gone. Survivors feel little has changed from their perspective to deal with the questions that they have consistently asked. My motion seeks to reflect that frustration. Survivors want to see an effective response from government and the many agencies responsible for this shame. No survivor has asked me for compensation. All, however, wanted to receive a meaningful apology and, if appropriate, a prosecution. But most importantly, they sought psychological support and aid to help them deal with their private nightmares. This is a difficult issue, there's no doubt of that. One I find personally almost overwhelming to cope with. We have a responsibility to answer clearly and simply the demands of survivors. If there is to be no response akin to a Northern Ireland public inquiry, will the Minister explain why? Will the Government reconsider their decision now? Will the Minister explain simply where the Government is today in answering the demands from survivors? She knows that survivors have little trust in the provisions currently in place to deal with this issue. Those provisions are convoluted, bureaucratic and bound to fail in the opinion of survivors, and they need a response. I know a number of members in the Chamber today have participated in this debate and have long-standing efforts on this issue. I am fresh to the subject and make no special claim to contribution. I merely ask the Minister on behalf of those who have suffered abuse, and some have come here to the public gallery tonight, still very much those children in our care. When do we play our part to help them survive? In December 2004, Kenny McCaskill, in his contribution to the debate that day, said, "There are none so blind as those who will not see, none so deaf as those who will not hear." Will we learn the lessons today, use our sight and our hearing, and answer the cries from victims for support and effective response? At that point, I'll end my contribution, and I look forward to the contribution from other members in the Chamber. Thank you, Presiding Officer.
Many thanks. I now open up the debate. Speeches of 4 minutes, please, as it is a heavily subscribed debate. And I call on Sandra White, to be followed by Margaret Mitchell.
Thank you very much, Presiding Officer, and can I thank Graham Pearson for securing this debate, justice for survivors of historic and institutional child abuse, a subject which is harrowing, as has been said previously, and definitely has an everlasting effect on its victims. It's also an issue which I have been involved in the Scottish Parliament since Chris Daly and others brought the petition to the Petitions Committee, very, very early on in the Parliament, early 2000, and was very much involved in the evidence sessions that was put forward as a member of the Petitions Committee. I was really proud of the way that the petition was presented to the Petitions Committee, the evidence that was given, and the way it was listened to and presented also. I'm also proud of what we've achieved so far, and I do mention and concur with some of the issues that was raised by and the comments by Graham Pearson. But I am proud of the fact that we took this petition, this very, very serious subject, through the Scottish Parliament to become one of the first Petitions Committee debates in the Scottish Parliament, culminating with an apology, as has been said by Graham Pearson, by the then First Minister Jack McConnell on behalf of all of the people of Scotland. That was something that never happened before, and it certainly highlighted this horrific situation, which has been ongoing also. And apart from the fact that it was heard in the Parliament and the First Minister gave the apology, it led on to the time to be heard, the pilot scheme in that particular issue, which we'd never done before. So I think it's something that everyone in this Parliament should be proud of, the fact that we put forward this, and now we now have the National Confidential Forum. Now, Graham Pearson mentioned the fact about the apology, and the apology law. And I know that Margaret Mitchell, my colleague, is going to concentrate on that particular one. The time bar is also mentioned within Graham Pearson's contribution and also in the motion which is there as well. And I think it's something that we can look at. Graham Pearson touched on the compensation issue, but certainly from my experience speaking to the people who presented the petition and also constituents of mine who have unfortunately went through this horrific experience, compensation in monetary terms is something that they did not seek. What they did want was recognition they went through this horrific situation and recognition that someone somewhere is responsible for it. Now, I'm glad that the Scottish Human Rights Commission has taken on board this project. It gave us a very, very good reading paper here in regards to what they are doing and what is being said within the forum. And being a member of the Justice Committee now, which is obviously the lead committee, although the Health Committee actually did the National Confidential Forum, I'm sure it will come back to the Justice Committee as the lead committee, and we will look at what's came out of what the National Forum and what's come out from the comments and the Constitution in that respect as well. I hope we will move on in regards to this terrible situation. Certainly people who have spoken to me do want some, not so much closure to an extent, they do want some form of closure, but at the end of the day, what they want is justice, and they feel they deserve the justice, and actually I think everyone in this Parliament feel they do deserve justice. Also, it's how we go about delivering that justice. So once again, I say I thank Graham Pearson for bringing this forward to the Parliament, being able to have this members' debate on that, and I look forward to the contributions that's forthcoming, and I look forward to the Minister's reply to the contributions. Thank you, Presiding Officer.
Many thanks. And I now call Margaret Mitchell to be followed by Neil Bibby.
Thank you, Presiding Officer. I congratulate Graham Pearson on tabling this motion for debate and welcome the opportunity to speak on the important issue of childhood sexual abuse. Remaining silent about this harrowing issue, often because it's just too hard to talk about, benefits no one except the perpetrators. So the more it's discussed and highlighted, the more it helps survivors and deters perpetrators. For the unpalatable truth is, the perpetrator is likely to be in a position of trust and/or known to the family, or even a family member, rather than a stranger. It's a cruel irony that children placed in care homes for their own well-being and safety became victims of historic institutional abuse. It's difficult to imagine anything worse than the trust of a child being betrayed in this grotesque way by the very people they have a right to expect to be there to protect them, whether that's in a family setting or in an institution. From the very first adult survivors of childhood sexual abuse cross-party group meeting I attended in 2003, and ever since, I have never failed to be moved and humbled by the extraordinary courage of adult survivors. For, as this motion states, all survivors, including survivors of historic institutional child abuse, continue to suffer from the legacy of that dreadful abuse. I fully understand that for them, acknowledgement of the abuse having taken place and achieving justice is an important aspect in moving on from this abuse. Here, the National Strategy for Survivors of Childhood Sexual Abuse is just one example of an important achievement that benefits abuse survivors, which was developed out of the efforts of the cross-party group. Furthermore, the Scottish Human Rights Commission, in its Action Plan on Justice for Victims of Historic Abuse of Children in Care, notes that the time bar is a real barrier to survivors getting access to civil justice. A point consistently made over the years by the cross-party group, who opposes the time bar and has made this view known to the government and relevant legal bodies. Furthermore, the convictions secured in the Max Clifford trial serve as a timely reminder that the time bar shouldn't be an obstacle to survivors seeking justice, and eliminating the time bar is therefore one way that justice could be achieved for survivors of historic abuse. For survivors of institutional abuse, the traumas of physical violence, emotional abuse and neglect are often in addition to the sexual abuse that many suffered. These combined to produce particular shame and fear of not being believed, which prevent many victims from coming forward until years later. There may also be memory problems as a result of great trauma that was sustained in childhood. In terms of a public inquiry, whilst I fully understand and sympathise with those survivors who have called for this, opinion among survivors is mixed. Survivors would be exposed in such an inquiry, and many don't wish it to be known that they have a history of abuse. Furthermore, given the inquiries already carried out into childhood abuse in children's homes in Edinburgh and Fife, together with the Care Law inquiry, it's difficult to see what yet another very expensive inquiry would reveal that these inquiries have not. I'm not convinced, therefore, that that's the best way forward. Instead, I believe the money would be better spent in helping to ensure the plethora of agencies which support and advocate for abuse survivors are adequately resourced. Agencies like Kingdom Abuse Survivors Project and Open Secret, based in Falkirk, operate throughout Scotland and have helped raise awareness in this issue, and brought healing, strength and courage and assistance to abuse survivors. Finally, Presiding Officer, the Scottish Human Rights Commission's Action Plan also advocates Scotland adopting apologies legislation in order to facilitate acknowledgement and accountability of historic institutional child abuse. I am therefore pleased to confirm that at the beginning of April, I lodged a proposal for a Members' Bill entitled the Apologies Scotland Bill, which would, if passed, allow the meaningful apologies to which Graham Pearson referred to be given to survivors and others.
Many thanks. I call on Neil Bibby to be followed by John Wilson.
Thank you, Presiding Officer. I join members in thanking Graham Pearson for bringing what is obviously a very serious and important issue to the Chamber. Like many members, I have been contacted by constituents on the issue of historic institutional abuse. As a former member of the Petitions Committee, it is an issue that I have followed closely. It is important to recognise that a number of survivors are here in the public gallery this evening, which is testament to their ongoing commitment and determination to securing justice. All parties and the Scottish Government need to listen to what our constituents are saying, because the reality is that since Jack McConnell's statement and apology in this chamber nearly a decade ago, progress towards justice for victims of historic abuse has stalled. The Justice Minister has said recently that the Scottish Government has spent £6.2 million on the Survivor Scotland programme since 2007. I would of course acknowledge the work that has been done to date, but the survivors I've spoken to feel strongly that this money hasn't had a direct impact on their lives. We need to listen to these concerns, because it's all very well for us to produce reports and frameworks, but if these are not being acted upon, if these are not directly benefiting the people they are intended to, then the simple fact is that the survivors of historic abuse are being failed. Survivors like those here today deserve much better. That's why I join Graham Pearson in urging the Minister to outline the concrete steps that the Scottish Government will take to secure justice for victims. As the motion highlights, the Scottish Human Rights Commission Action Plan outlines a number of options for achieving proper acknowledgement and accountability. Many of the survivors I've spoken to feel that the issue of acknowledgement was addressed by Jack McConnell's apology in 2004. However, I've listened to other members saying that more can be done in that area. But many of the survivors that I speak to see accountability as the priority now. There are a number of issues and questions that my constituents have specifically asked me to raise today. Will the Scottish Government take real action to remove the time bar as a barrier to civil justice for victims of historic abuse? Will the Scottish Government work with others to create a national survivor reparation fund? And do the Scottish Government support the establishment of a public inquiry? My constituents are asking this because they have not seen a public inquiry, and they are asking this because the Cabinet Secretary for Justice, Kenny McCaskill, supported this back in 2004, and I understand the current Justice Minister, Rosanna Cunningham, said in 2003 we need a major inquiry in Scotland into this issue. The survivors I've spoken with point to the inquiry in Northern Ireland, which provides a legal avenue for victims to pursue, as well as a confidential forum. I know many survivors strongly believe that such a legal route should be available in Scotland. In fact, one such survivor recently told me that out of over 430 applicants in Northern Ireland, only 46 have chosen to go down the route of the confidential forum, demonstrating the support to pursue justice by legal means in a judge-led inquiry. Presiding Officer, my constituents believe Scotland is lagging way behind other countries on this issue. We need to learn lessons, but also reveal the truth as well. The Historic Abuse Systemic Review, published in 2007, highlighted the fact that there are a number of legal issues in need of investigation. The review learned that senior people had ordered records to be destroyed. This alone is scandalous and needs further investigation. It also said many children died whilst living in children's residential establishments. Some organisations have identified the children in graveyards, but in other cases, searches have yielded few records identifying children or information about why they died. This reinforces the need for more comprehensive action than the Scottish Government is currently offering. Presiding Officer, survivors want real action. I would urge the Minister not just to listen to me, but to the voices of survivors, those in my constituency and those in the public gallery. If the Minister progresses the actions being called for, then she will have my full support. The survivors deserve justice.
Many thanks. John Wilson, to be followed by Michael McMahon.
Presiding Officer, may I add my congratulations to Graham Pearson on bringing forward the motion for this members' debate. I believe that it is extremely important to recognise, as is in the motion's intention, the value of ensuring that access to justice is vital to the legacy of abuse felt across modern Scotland today. Despite the fact that, as the motion states, steps have been taken to address the matter of institutional child abuse, Graham Pearson quite rightly makes it clear that much more needs to be done on this legacy of abuse. This is not a comfortable subject area, with wrongs having been committed, and quite rightly protecting the victims of this type of crime is paramount. There can be no doubt that after the almost constant stream of daily allegations surrounding child sexual abuse and other levels of abuses, historic and otherwise, then the need for accountability is high. This debate is important, and one I come to from having been a member of the Public Petitions Committee and examining Petition 1351, A Time to be Heard. It is worth noting that not all persons abused are looking for compensation. Graham Pearson quite rightly identified that issue. In many cases, they are just looking for some acknowledgement and accountability for those in charge in relation to what happened to them while they were in care. The Scottish Government has taken some steps to address the issues raised, with funding being provided to the Time to be Heard Forum, for example. In my contributions at the Public Petitions Committee, I have highlighted the fact that the data and access to historic records are vital in terms of empowering survivors of this terrible abuse. And as Neil Bibby has highlighted, some of those records have been destroyed by the organisations who were in charge of children at that time, a point reinforced by the action plan produced by SHRC. In consideration of the petition, the Public Petitions Committee has always been well aware of the issue of the time bar when looking at evidence, and constraints of the time bar is a real important point in terms of identifying and replicating good practice. Modern Scotland has taken some steps to address the issue through the Scottish Human Rights Commission, and the Scottish Government has quite rightly engaged with the interaction on historic abuse of children in care. We must realise that what we owe the victims is a legacy that is open and honest. The Scottish Government clearly has a role in developing and sustaining the National Confidential Forum, which came from the previous consultation. I appreciate that Graham Pearson is coming from a particular viewpoint on this motion of looking for a full public inquiry, and I have certain sympathy with that stance. Although public inquiries do have a rather chequered history, particularly in recent times, and not every victim is looking for a public inquiry. For many of those victims, they feel by publicising or coming forward to declare their abuse that took place to them would actually highlight further stress and strains on their mental health and their well-being. Graham Pearson... I don't have time, sorry, Mr Ferguson, unless the presiding officer allows me.
Well, I'll allow a brief intervention. Alex Ferguson.
Thank you very much, President. Thank you, Mr Wilson. I just wonder whether he would agree with Nicola Sturgeon, who wrote to the Petitions Committee in 2004, when she said, "I appreciate there are survivors of abuse who would not welcome an inquiry due to the trauma this would cause to them. However, we must also consider those who do wish an inquiry." She was very supportive of an inquiry in 2004.
John Wilson.
Thank you, Presiding Officer, and I don't disagree with Mr Ferguson. There will be people who will welcome the opportunity to come forward to an inquiry, but there are other victims who will feel too onerous to actually give the evidence at a public forum. And that's why the time to be heard was established to allow those people to come forward confidentially and give some information. Graham Pearson, quite rightly, is looking for justice now and in the future. That said, we need to learn difficult lessons from the past, particularly when, as had been highlighted in various media outlets in recent months, a significant number of sexual abuse cases have placed the spotlight on those who take advantage of holding influential and powerful positions in society to the detriment of victims who are less likely or unable to fight back, be that through fear of persecution in the public eye or a belief that their voice will not be heard. I look forward to the ministerial response tonight to the issues raised and in the debate today, and it is my hope that we can right the wrongs that were perpetrated during these dark days and establish systems in place which do not see a repeat of these abuses of the past, and we as a society can move forward confident that we have rooted out the difficult times that people faced in the past and we see a better society for tomorrow. Thank you.
Thank you. I don't wish to curtail the debate, and due to the number of members who still wish to speak, I'm therefore minded to accept a motion from Graham Pearson under Rule 8.14.3. That debate be extended by up to 30 minutes. Mr Pearson.
Presiding Officer, I'd like to propose that motion.
Many thanks. Is Parliament agreed? We are. In which case I call Michael McMahon to be followed by Alex Ferguson.
Presiding Officer, I congratulate Graham Pearson on securing this evening's debate and once again pay tribute to the commitment, dedication and tenacity of those survivors of institutional child abuse who have fought tooth and nail to have this issue firstly raised and then kept on the agenda of this Parliament. Time after time in this Parliament, we commend ourselves on being at the forefront of issues and in leading the way on challenging subjects. When we do, we are right to highlight why having a Scottish Parliament benefits the lives of Scotland's people. Yet here we are again, 12 years on from the lodging of Petition 535, and we are still asking why a satisfactory conclusion to past institutional child abuse has not been delivered. As convener of the Public Petitions Committee in 2004, I was proud to play a part in securing an apology from the then First Minister Jack McConnell on behalf of the people of Scotland for the abuse which affected far too many children who had been in the care of the state. I felt it to be a positive step that following that apology, a commission was then established to look into historic abuse and recognise that that review is thought by many to have had a positive impact on residential care in Scotland since that time. But as Neil Bibby highlighted, the review identified a number of areas which have not been progressed in the intervening period. So here we are, no longer leading on this matter, but watching country after country confronting their past failings and putting in place measures which do not just acknowledge the damage of the past, but seek to address the consequences of that shameful legacy. Now, I've met with many survivors of in-care child abuse since my involvement with Petition PE 535, and as well as my admiration for their strength and courage, I've been impressed by their desire for justice and not retribution. However, the sense of abandonment has been what has struck me most. Yes, there is anger, there is hurt, there is pain. Lives have been decimated, and even those who have led successful lives after leaving childcare institutions have conveyed to me an impression of misery caused by the struggle to cope with what happened to them in their early lives. But they have not used those emotions in a negative way, but in a fair and reasonable manner to pursue support, help and advice, and not just for themselves, but for those that they know who suffered but could not find the strength to fight themselves. So I earnestly implore the Minister tonight. I know you've spoken to these victims. I know that you've heard their pleas. But what they need you to do now is stop listening to your civil servants and tell them to get on with putting in place the same remedies for Scottish abuse survivors that have been established right across the world. Give them a public inquiry so that they too can obtain justice like those in Ireland, in Australia and elsewhere. Let us get back to where we were in 2004 and lead the way in confronting what happened to those people who, when they should have been cared for by the state, were let down by our administrations and our institutions. Let us stop hiding behind bureaucracy and let us once and for all answer the call of the abused. They want justice.
Many thanks. I call Alex Ferguson to be followed by Elaine Murray.
Thank you, Deputy Presiding Officer, and can I, like others, begin by congratulating Graham Pearson both for bringing the debate to the Chamber and also for the way in which he introduced the debate. I'm also very grateful to him because it gives me an opportunity to share just a few thoughts within the Chamber which have been formed largely as a result of my having worked with a constituent for far too many years now, trying to help him bring closure to the truly horrendous childhood experiences that he and his brother underwent when they were entrusted to the so-called care of Quarriers Homes. Sadly, that trust turned out to be entirely misplaced, and the abuse to which they were subjected has impacted on their lives in ways at which most of us can only hazard a guess, and even then, I suspect we don't come anywhere near the reality of the horror that they face on a daily basis. My constituent did everything possible to seek justice through the courts, but his attempts were rejected at every turn. His brother, on the other hand, received national press coverage in 2008 after Quarriers agreed to an out-of-court financial settlement with him when he succeeded in bringing a case to court, and I'll return to the significance of that later. In 2010, Dumfries and Galloway Council agreed without question to compensate people who were identified as having suffered abuse at the hands of an individual employee in a council-run residential home during the 1970s. Now, despite the fact that previous attempts to sue the council had been dismissed in court as being time-barred, the council commendably took it upon itself to hold up its hands, accept liability, and take action to compensate the victims, and importantly, to apologise publicly. Now, while I agree that no amount of money could ever compensate for the abuse received and the consequential impact of that abuse, the simple message that the responsible organisation apologises publicly and recognises its responsibilities must in itself be of considerable comfort to those who have suffered the abuse. So we have one organisation that does its damnedest to bring closure for its victims, while another hides behind the time bar law, simultaneously buying off a potentially devastating court case with an out-of-court settlement for one individual whose brother can't even get a public apology from that same organisation. This is a somewhat chaotic situation, and I would argue that it cannot continue, Presiding Officer. I accept that the Time to be Heard initiative was very well intentioned, but it has failed to bring any measure of closure to many who took part in it, including my constituent. And if there's a clear message that comes out of all this, it is surely that there is no one-size-fits-all solution. Every case, every individual has a different route to personal closure. And that's why I think any future government action must involve serious interaction and engagement with the survivors themselves, first and foremost. And that's why I very much commend the action plan on justice for victims that the motion refers to. And I particularly want to highlight just two proposed commitments within that action plan. The first is that consideration be given to a national inquiry on historic abuse. And the second is for a review of the way in which the time bar law operates. And interestingly, both of these commitments were vigorously supported by no less a figure than the Deputy First Minister when she was in opposition. It seems a shame that she hasn't brought that same level of commitment with her into government. Presiding Officer, I spoke to my constituent at lunchtime today to tell him that we were having this debate. And he said quite simply, can you just tell them that all we really want is to be listened to and to be believed? Because when we were children, no one listened to us and nobody believed us. We can put that right, Presiding Officer, and I hope this debate helps us take a step in that direction. Thank you.
Many thanks. I now call Elaine Murray, after which I will call the Minister.
Thank you very much, Presiding Officer. And as others have said, at the end of this year, it will be 10 years since First Minister Jack McConnell apologised to victims of child abuse in Scottish residential care homes on behalf of the people of Scotland. And yet, as we have heard, despite reports commissioned by the Scottish Government and forums set up, survivors are still denied access to justice for the appalling abuses of their human rights, abuses which frequently have affected the rest of their lives. These most vulnerable of children, whose families were unable to care for them, and therefore didn't have mums or dads able to look out for them, towards whom the state should have displayed the greatest possible care, were abandoned to predatory adults, often in a position of authority over them, and in some cases also to abuse by other children. And we know it wasn't just the odd aberrant institution. It happened in residential accommodation across the country over decades, probably indeed over centuries. Tom Shaw's report, published in 2007, estimated that around 1,000 children were abused in the Scottish care system between 1950 and 1995. And over the decades while this has been going on, society has looked the other way. Yes, there has been interest in the perpetrators, especially there's interest when those perpetrators are celebrities, but the experiences and needs of the victims have received less attention. I have had some contact with the survivors of the Markland Children's Home in Dumfries and Galloway, which Alex Ferguson referred to. Markland was a residential children's home in Moffat, which was opened in the 1960s by Dumfries County Council, and later operated by the Regional Council. When Peter Harley became officer in charge in 1977, he developed the home to accommodate what were described as more difficult young people coming through the children's hearing system. I suspect that this was deliberate because these were the ones least likely to be believed. And he subjected the children in his care to a regime of physical and sexual assault. Some 200 children came through Markland during the 5 years he was in charge. 47 victims have come forward, but there is no knowing of how many, the total number of children who are actually abused by this individual. Harley's crimes were not revealed until 1994, when one of his victims was being taken to court, and he advised his social worker that his offending behaviour was the direct result of the abuse he had suffered at Markland. In the meantime, another victim had killed himself, another had drank himself to death. In 1996, Harley was sentenced for 15 years imprisonment. He received a further sentence of 8 years for further offences revealed later, but he was released from prison after only 10 years. 5 victims, as Alex Ferguson said, did try to sue the local authority. Their cases, of course, were dismissed by the Court of Session in 2005 as being time-barred, and that is something that we do need to address. In 2009, however, Dumfries and Galloway Council took the decision to publicly apologise and to make individual ex gratia payments of £20,000 to each of the adult survivors. And I too believe the Council has to be congratulated for that. It was not forced to do that. It chose to take responsibility, but many other authorities have refused to do so. And we know that various reports have been commissioned and the National Confidential Forum is being established. But are we really any closer after 10 years in ensuring that responsibility is taken for what happened to those hundreds, possibly thousands of child victims who were let down by those who were supposed to be looking after them? I believe too that a public inquiry, possibly along the lines of Northern Ireland's historic institutional abuse inquiry, which, as Graham Pearson has said, is inquisitorial rather than adversarial, and that might address some of the concerns that some others have expressed on behalf of victims. That could identify the systematic failings by the institutions or the state in their duties of care towards these children, and what support, whether it's apology, compensation, therapeutic interventions, would benefit survivors and meet their needs. And I do believe that Scotland is now, having been at the front, is now lagging behind other countries in taking responsibility. But abuse is also still happening, because it's only in November last year that a care worker was sentenced to 6 years for sexual offences against 3 young girls in West Dunbartonshire. And the other important thing a public inquiry could do was to help to identify the additional measures which need to be taken to prevent future incidents. Though it strikes me that overall, what we need to actually understand is the process of the abuse of power, because that's what all this came down to in the end, was the abuse of power by people in positions of authority over those who are vulnerable. And unless we actually begin to address that, we will never put this right for our victims.
Thank you very much. Can I now invite Rosanna Cunningham to respond to the debate? Minister, in around 7 minutes, please.
Thank you, Presiding Officer. Can I congratulate Graham Pearson on this debate, and particularly for the careful and sympathetic way he handled what is a very difficult subject. And I may say the same about all the members who have spoken this evening. I do want to start by responding on some of the issues which lie directly within the Justice portfolio. Members will, of course, realise that a number of aspects of this debate do range into the Health portfolio as well. I will address those, but I'll first deal with some of the Justice issues. I think it's probably useful for us just to remind ourselves at the outset that there is no time bar in relation to criminal prosecutions, and that what this debate tonight is about is entirely the civil justice aspect of the law in Scotland. I think sometimes, and I'm not suggesting that members tonight have been in that position, but sometimes I think there is a kind of blurring of the conversation around that. And there is no time limit in the criminal law in Scotland for raising prosecutions in respect of any case. So really what we're talking about tonight is all connected with the civil law alone. In relation to claims raised under the civil law, it is in the interest of all members of society to have an effective framework that allows cases to be resolved quickly and fairly, and that's really both sides of the coin here. We've consulted on a range of issues, as some members will probably be aware, relating to damages for personal injury, and that was based on Scottish Law Commission recommendations. Now, as modest as those recommendations were, and I'll say a little bit more about them, there was no clear consensus on many of them. For example, in relation to time bar, there was not even universal agreement on the move from a 3 to a 5-year limitation period for personal injury claims. 5 years is the current limit for financial loss. And while it always seemed odd to me that you got more time to contemplate financial loss than personal injury, yet even that modest recommendation couldn't attract widespread support. And I think people need to remember that there is a bigger issue about time bar we need to look at. The Scottish Law Commission did not recommend that special provision be made for any specific category of pursuer. The SLC recommendations recognise there is merit in a limitation period which will apply universally. They also, however, made recommendations which would enable the personal circumstances of pursuers to be taken into account when considering time bar. And we do need to exercise some caution when we make comparisons with what other jurisdictions have done. I know members tonight haven't done that. I don't think I recall anybody doing that. But many of those who have removed time bar from their systems did not have the judicial discretion available to our judges to disapply the time bar that we have in Scotland. Now, I know there is a controversy about whether or not the judges are actually applying that discretion as widely as they could, but we do think that it is a valuable tool to enable time bar issues in difficult and hard cases to be properly considered, and we do have the capacity to expand and enhance that existing part of our system. I should also say something about the apologies issue and the bill being promoted by Margaret Mitchell. I have, of course, met Margaret Mitchell to discuss the bill, and the aim of the proposal to encourage and protect the giving of apologies by private and public bodies to achieve a better outcome for victims and to reduce the number of cases which result in litigation is absolutely desirable, and I would want to put that on record. The devil, of course, is always going to be in the detail, and I've had this conversation with the member, so until we've actually seen the final proposal, it's hard for me to take a firm view, but I do look forward to continuing to work with the member on this issue, and I do agree that it is a significant part of this entire debate that we look very closely at the capacity for us to introduce something along those lines. So I've talked about a couple of the very direct justice portfolio issues, but of course there is a range of work across the Scottish Government being taken forward. Now, I was disappointed that the motion didn't refer to the National Confidential Forum, so I'm very glad that Graham Pearson did raise it in his opening speech. The forum is another way in which we are acknowledging and recognising survivors of institutional child abuse and other former residents. And we've built on the Time to be Heard pilot forum and legislated for the NCF through the very recent Victims and Witnesses Scotland Act. We've had great support from survivors who've given us their advice about the legislation and about how the NCF should operate, and it's good that this debate does give me the chance to thank them for their contribution so recently given. The NCF will give survivors of institutional child abuse the right to give their testimony to an independent panel in whatever way they choose. The Forum has a statutory duty to signpost services that may be useful to participants. It will make it easier for survivors to report abuse allegations to the police. It will also benefit children now by highlighting why abuse happened in institutions and what can be done to prevent abuse happening in the same settings today. We know that survivors are very keen to prevent any child being abused, and their testimony at the NCF will be an important part of that. Members will be happy to hear that we hope to have the Forum operational in the autumn of this year. Now, Presiding Officer, it is likely I will overrun my allotted 7 minutes, but I think the issues are important enough to allow that to happen with your indulgence.
Yes, indeed.
If I could turn now to the Survivor Scotland strategy, which a number of members did raise. It is now almost 10 years since it started the groundbreaking work that it began in 2005. And under the strategy and with the advice and support of survivors, support agencies and other stakeholders, many projects are providing a huge range of services to thousands of survivors. In that time, we've invested over £6 million, and I think it was Neil Bibby that specifically referenced that. More than £1.5 million will have been spent on establishing the support agency, the InCare Survivors Service Scotland, which will be up and running next year. So these are concrete things which are actually happening right now. I wouldn't like people to go away with the impression that somehow everything has stalled. It hasn't. Things are continuing to happen. I'm also pleased that the motion highlights the SHRC's action plan. We've worked with the Commission and other stakeholders in the interaction, and we do think this has been a very valuable process. It would be premature for me to make any response about the commitments proposed in that plan until after we've seen the results of the consultation on the plan. The Government hopes to be able to make a full response next month. Unfortunately, the debate is this month, and I know that everybody who has spoken in this debate will be looking eagerly to see what that response is. And that will include a decision on a reparations scheme mentioned by a few speakers, including Graham Pearson, Sandra White and Neil Bibby. The Government is still committed to scoping out a possible reparations scheme, and I think I need to put that on record. However, as I said just there, we need to wait until we see the outcome of the consultation on the action plan. Now, that leads me on to the bigger issue of the public inquiry, which a number of people have raised, not everybody being absolutely convinced about the necessity of it. And I have to say, again, that is reflected in both the interaction and also in some of the other contributions. There isn't a unanimity around this. The motion speaks about a full public inquiry. It is important, however, to note that the action plan doesn't include this in its recommendations, and it did look carefully at it. The concerns around the issue of an inquiry included that it might take a very long time, the outcomes might not offer tangible support, that it might be expensive, and that it would have the potential for conflict and further trauma. Now, these are not glib reasons for being unconvinced about a public inquiry. They're carefully thought through reasons in that interaction process, and I do think we have to listen carefully to that. I would want not to be in a position of saying never, but I do think we have to listen very carefully to the conflicted views on this and not assume that there is an absolute unanimity on this. We are running quite late. Is the Presiding Officer...
Briefly, please. Yes. Graham Pearson.
I would be very grateful if the Minister would give an assurance that she would look at the possibilities in a very critical sense and really measure the benefit it brings to victims to engage in that public inquiry, should it be deemed the best way forward. Minister.
The difficulty is that some victims expressly didn't want a public inquiry. So I think this is one of the difficulties that we have in this. And a number of people have referenced the Northern Ireland inquiry. I should just say that the Northern Ireland inquiry took the form of 3 different components, 2 of which are already reflected in things that we are currently doing. We just haven't badged it in that way. So I think we just have to be a little bit careful about assuming that something is differently happening when you know. So, well, you know, you may find that the third bit doesn't actually bring necessarily what is required. So, you know, there were a number of survivors and other stakeholders not convinced that this was a good option, and they considered there'd been enough reviews and inquiries. Some of them have been mentioned already: the Kerlaw, the school inquiry, the historical abuse systemic review carried out by Tom Shaw. But we have agreed to commission an independent exercise by experts at the Centre for Excellence for Looked After Children in Scotland. So there is a lot happening and still more in progress. And I would ask members to recognise that. It's a very difficult, very complex subject that ranges over a wide range of policy areas within government. It would be wrong to give the impression that nothing was happening. It may not be happening badged in the way that people want it to be badged, and that's a slightly different issue, but there is a great deal concrete progress currently in play and some coming on stream. And I would ask members to look out for that when they see it happening. And as always, and as offered prior to this members' debate, both myself and my colleague Kenny McCaskill are happy to meet people if that's what they wish, to talk through some of the issues that we've discussed tonight. Thank you, Presiding Officer.
Many thanks, Minister. That concludes Graham Pearson's debate on justice for survivors of historic institutional child abuse, and I now close this meeting of Parliament.